There has been a fair amount of focus lately on the CDC eviction moratorium, including the court findings and the fact that President Biden ignored them. By doing some research, we can find out the facts of this case, including the good, bad, and ugly when it comes to the constitutionality of the different actions taken. Let's take a look at those details and determine for ourselves what we should do about it. So we'll do that next on the Constitution Study.
There's one thing you have to know wherever you make your stand. Came from a long through line of everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study. I'm glad you could join me. I just got back through my Northern Plains leg of the Knowing Your Rights tour. I had a lot of fun. I saw a lot of great people, a lot of interesting landscapes, but most importantly, I met people that were starving for information, just absorbing details and seeing light bulbs go off as we understand that we are not the subjects of government. We are actually its master. That also means it's up to us to do something about the problems that are happening. So I urge you to go over to constitutionstudy.com to find out more. Please share this video, share the articles, share anything you find there. It's absolutely free. And you can help your neighbors learn a little bit more about what it is to be a citizen in a free republic. Now, I'll give you some more information at the end of the video, but for now, let's go talk about these CDC eviction moratoria. Our story starts back in March of 2020. Now, from the opinion of Tiger Lily LLC versus U.S. Department of Housing and Urban Development, we read, in March of 2020, Congress passed the Coronavirus Aid, Relief, and Economic Security Act. Among other things, the CARES Act imposed a 120-day moratorium on evictions from rental properties that participated in federal assistance programs or had federally backed loans. In March of 2020, we knew relatively little about the SARS-CoV-2 virus and the disease it caused, COVID-19. The model used were absolutely frightening, so many Americans were terrified of COVID-19. Did that fear mean that the Constitution doesn't matter? Did Congress have the authority to dictate how our private owners of property run their businesses because they receive federal assistance or federally backed loans? The answer to both questions is no. They could make the federal assistance contingent on voluntary moratorium standards, but unless the loan contracts allow the United States to change the requirements without the approval of all parties involved, the loans should be unalterable. However, in no situation does Congress have the legal authority to enact such a moratorium. After that congressionally enacted moratorium ended, the CDC stepped in. It issued an order entitled Temporary Halt in Residential Evictions to Prevent the Further Spread of COVID-19. The HALT order imposed a broader eviction moratorium than Congress had, one that prohibited evictions of all covered persons without regard to whether the rental property relied on federal funds or loans, through December 31st of 2020. The CDC explained that the order is a necessary measure to facilitate self-isolation, support state lockdown orders, and prevent congregation in settings like homeless shelters. When Congress' illegal moratorium ended, the CDC enacted its own. Not only did the Trump administration continue this illegal act, it expanded it to all covered persons, regardless of whether there was federal financial involvement or not. The CDC explained that the order was necessary to help people to isolate themselves and support these illegal lockdown orders the states had been issuing. Now, where did the CDC claim it had received the authority to issue such an order? The CDC found authority for its entry into the landlord-tenant relationship in the Public Health Service Act of 1944, which authorizes the Secretary of Health and Human Services to make and enforce such regulations as in his judgment is necessary to prevent the introduction, transmission, or spread of communicable disease. That's Title 42, U.S.C. Section 264A. To carry out and enforce such regulations, the Secretary can provide for such inspection, fumigation, disinfection, sanitation, pest extermination, destruction of animals or articles found to be so infected or contaminated as to be a source of dangerous infection to human beings, and other measures as in his judgment may be necessary. Now, I'm wondering, how does the authority to create regulations to provide for inspections, fumigations, disinfections, sanitation, pest extermination, and destruction of infected animals or articles morph into the authority to interfere with a contract between a landlord and their tenant? The answer is it's only in the mind of petty tyrants who use any excuse to get the outcome they want. Now this, the latest example of the philosophy that the ends justify the means, is not only destructive to rights and liberty, but also the very idea of the rule of law. Now it didn't take long for people to seek a redress from this grievance. Tiger Lily LLC owns and manages rental properties, filed suit in district court seeking both a declaratory judgment and preliminary injunction barring the moratorium's enforcement. The district court denied the injunction because it found that the loss of income was not an irreparable harm. However, after the court heard the case, it found that the moratorium did exceed the statutory authority granted under 42 U.S.C. 264A. Not surprisingly, the government immediately appealed and requested both the district and circuit courts issue an emergency stay pending the appeal. The circuit court denied the request, stating that they thought the government was not likely to succeed. Sure enough, after hearing the appeal, the circuit court found that 42 U.S.C. section 264A does not authorize the CDC to implement a nationwide eviction moratorium. Now, before we go on, notice the details of what both the district and circuit courts found. Not that government interfering with the rental contract is not a power delegated to the United States, and not that a blanket prevention of landlords from evicting renters who violate the contract is a deprivation of property without due process of law or a violation of the Fifth Amendment. No. They found that when Congress passed 42 U.S.C. 264A, they did not authorize the CDC to issue such a regulation. Now, this mistake will be repeated as this fiasco continues. Alongside the Tiger Lily case, the Alabama Association of Realtors filed suit against HUD. The district judge for the District of Columbia vacated the order. Why? The court recognizes that the COVID pandemic is a serious public health crisis that has presented unprecedented challenges for both public health officials and the nation as a whole. The pandemic has triggered difficult policy decisions that have had enormous real-world consequences. The nationwide eviction moratorium is one such decision. It is the role of the political branches and not the courts to assess the merits of policy measures designed to combat the spread of disease, even during a global pandemic. The question for the court is a narrow one. Does the Public Health Service Act grant the CDC the legal authority to impose a nationwide eviction moratorium? It does not. Because the plain language of the Public Health Service Act, 42 U.S.C. section 264A, unambiguously forecloses the nationwide eviction moratorium, the court must set aside the CDC order, consistent with the Administrative Procedures Act, see Title 5 U.S.C. section 706 2C, and D.C. Circuit precedent, see National Mining Association. Yes, COVID-19 has become a crisis, as the evidence mount that not only is COVID not a generally deadly disease, but that the data that has been used to scare the world into serfdom is suspect at best. Even taking for granted the court's statement that COVID-19 is a serious public health crisis, the law is the law, and the law does not authorize the CDC to issue a nationwide eviction moratorium. Once again, nothing is mentioned about the Fifth Amendment's prohibition of taking property without due process of law, only that Congress did not authorize the CDC to issue the moratorium. Now, this decision was appealed to the circuit court with a request that the court issue an emergency stay pending appeal, which was granted by the judge, meaning the eviction moratorium remained in place. The Alabama Association of Realtors filed an emergency motion to vacate the stay, but that was denied. This request made its way to the Chief Justice of the Supreme Court, who referred it to the court. This request was denied, but this is also where the reporting gets extremely questionable. News media and pundits alike have claimed that the Supreme Court ruled that the moratorium was unconstitutional. Not only did the court issue no such opinion, no court record I found even questioned the constitutionality of the moratorium, but only whether the CDC had been granted the authority by Congress. In fact, when the court denied the application to vacate the stay, they left the moratorium in place. Now, while the court did not publish an opinion on its decision, Justice Kavanaugh did publish a concurrence. I agree with the district court and the appellants that the Centers for Disease Control and Prevention exceeded its existing statutory authority by issuing a nationwide eviction moratorium. So if Justice Kavanaugh agrees with the district court and the CDC exceeded its legal authority in issuing a nationwide moratorium, why did he vote to deny the motion? Because the CDC plans to end the moratorium in only a few weeks on July 31st. And because those few weeks will allow for additional and more orderly distribution of the congressionally appropriated rental assistance funds, I voted this time to deny the application to vacate the district court's stay of its order. Because the moratorium was scheduled to end in a few weeks, Justice Kavanaugh punted both his responsibility and his oath to support the Constitution of the United States. But we don't know why the other justices who voted to deny the motion did so, only that Justices Thomas Alito, Gorsuch, and Barrett would have granted it. And as if dereliction of duty were not bad enough, Justice Kavanaugh went on. In my view, clear and specific congressional authorization via new legislation would be necessary for the CDC to extend the moratorium past July 31st. Now, if these legals, supposedly the best legal minds in the nation, cannot see the blatant violation of the supreme law of the land in this moratorium, who can? Justice Kavanaugh admitted in his concurrence that he believes Congress has the authority to authorize this type of moratorium. Are we being led by idiots? I've heard experts claim that this is a violation of the Takings Clause, but it's not. Not only is the property not taken, it's not being used for public purposes. As the Fifth Amendment says, nor shall private property be taken for public use without just compensation. What I have not heard is a single lawyer, judge, constitutional professor, or anyone that participates in the judicial system point out that this is a violation of the Fifth Amendment's Due Process Clause, which reads, "No person shall be deprived of life, liberty, or property without due process of law." This should be an open and shut case. Any judge with the slightest knowledge of the Constitution should need no more than 30 seconds to decide it. The CDC's eviction moratorium deprives the landlords of this country their property, specifically the control of their property, without due process of law. No one has shown that these landlords violated any law. No evidence has been provided showing a widespread right to occupy rental property without paying rent. Only the concerns by those of the CDC that should people be evicted, they may go into a homeless shelter, creating an overcrowding condition. Of course, that situation only exists because governments, starting with state and local governments, shut down their economies, preventing people from working to earn the money to pay the rent. And nowhere has anyone made accommodation for the landlords who are still expected to pay mortgages, utilities, and yes, taxes on the properties they can no longer generate income from. And the atrocities did not stop with the Supreme Court decision. When the moratorium expired on July 31st, guess what happened? President Biden's CDC simply extended it yet again. Not only has Justice Kavanaugh been shown to be a fool for thinking this would not happen, but District Court Judge Dabney Friedrich has shown herself to be one as well. According to the opinion memorandum for her stay, she notes the substantial economic hardships as a result of the CDC's nationwide moratorium on evictions. However, she states that given the public health consequences cited by the CDC, a stay is warranted. Even though the CDC used a study that had not been peer-reviewed, they made claims about cases and deaths which seem more like wild guesses than actual scientific data. How big was this tremendous spike that should crush the rights of the American people? Well, the wild guess from the CDC expected about a 1 to 1.5% increase in cases and deaths nationwide. Based on the CDC's recent history of exaggerating numbers, I don't have much trust in those numbers at all. Now, people far and wide cried foul, claiming that President Biden was violating the rule of law by ignoring the opinion of the Supreme Court. Lost in the hue and cry was the fact that the court itself decided not to vacate the stay of the district court's opinion. or the fact that as a separate branch of government, the court has no authority to order the executive branch to do anything. According to the Supreme Court in Marbury versus Madison, the authority therefore given to the Supreme Court by the act of establishing the judicial courts of the United States to issue writs of mandamus to public officers appears not to be warranted by the Constitution. See, there were two questions the Marbury versus Madison court had to decide. First, did Mr. Marbury deserve the commission to the position he had been appointed to by the previous administration? The answer was yes. And second, did the court have the authority to order the president to issue the commission, in legal terms, a writ of mandamus? The answer was no. See, issuing this writ would have effectively placed the court and Congress above the president, something not authorized by the Constitution. Since the courts in this case did not find the moratorium unconstitutional and only authorized by statute, the claims that the president's actions were unconstitutional seem somewhat hyperbolic. Yes, the president was not faithfully executing the laws of the United States, but that's not what's being claimed. The fact that the president disagreed with the court and acted based on his opinion is not a violation of the Constitution, even if the eviction moratorium is. It's not just that the court trusted the questionable expected outcome from the CDC, but that they put it above the law. Again, from the Marbury versus Madison opinion. Thus, the particular phraseology of the Constitution of the United States confirms and strengthens the principle, supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void, and that courts, as well as other departments, are bound by that instrument. Here we have an executive department claiming powers not included in their statutory charter, powers that, even if Congress had authorized them, would violate the Constitution of the United States and therefore be illegal. What truly disturbs me, though, is the absolute disregard for the oath of so many in both the executive and judicial branches of our government. When those we have hired to protect our rights abuse them so badly, how can we trust them at all? From the Declaration of Independence, we read, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and pursuit of happiness. To secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. That whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it." What do we do when governments created to protect our rights not only fail to do so, but actively subvert them? Yes, we have the right to alter or abolish such government. It is not insurrection to attempt to restore the Constitution to its rightful place as the supreme law of the land. As Abraham Lincoln said, the people are the rightful masters of both Congress and the courts, not to overthrow the Constitution, but to overthrow the men who pervert it. Ultimately, it's up to us to overthrow those who are perverting the Constitution. That includes the judges and justices of the courts, the members of Congress, and those in the president's administration who are betraying their oath of office. The future of America rests in the hands of its people. Again, from the Declaration of Independence. But when a long train of abuses and usurpations, pursuing invariably the same object, evidence a design to reduce them under absolute despotism, it is their right, it is their duty to throw off such government and to provide new guards for their future security. Will our future be secure? Or will we fall under the absolute despotism of those in the federal government? I've seen plenty of talk about the CDC moratorium, but as I said, I haven't seen anyone talking about the fact that the whole idea is unconstitutional. They're more worried about what President Biden did or what this court did. The reporting on the court's opinions, especially the Supreme Court, has been absolutely atrocious. I believe it was Jefferson that said you can no longer trust anything that's in the polluted waterway of the media, and that seems to be the case nowadays. The courts never found the eviction moratorium unconstitutional. I wish they had, but they hadn't. The Supreme Court never found anything at all. All it decided was they were not going to vacate a stay. And even Justice Kavanaugh, when he published his concurrence, only said, I'm doing it because, well, I think the moratorium is wrong, but it'll be over in a few weeks. See, this is what happens when we let illegality and tyranny slide because we think it won't hurt that bad. Think about this for a second. You have the supreme law of the land designed to protect your rights. You have a president of the United States whose sole purpose whose primary purpose, I should say, is to execute the laws of the United States, including the Constitution of the United States. And he failed. His judicial branch not only failed to enforce the law, they actively defied the law. Now, they may have had a good reason, but if we let the ends justify the means, your rights mean nothing. I believe it was James Madison that said that democracies do not protect your rights. And it's funny that we tend to call ourselves a democracy. Yet here we have our elected representatives trashing our rights, and the American people do nothing. To me, it's a sad state of affairs. It's why I'm spending so much time and blood and effort to try to educate the American people. And you can help. Again, head to constitutionstudy.com. Take this article, take this video, take anything you find there, read it, use it, share it. That's all I ask. If you read it, share it with somebody. In my tour, I was referring myself to a constitutional Johnny Appleseed, planting seeds in people's hearts about rights and liberty and freedom and self-government. Well, if I'm planting a seed in your heart, help me spread those seeds to other people as well. Because this is not going to get fixed in Washington. Washington is too corrupt to fix itself. It's not going to happen. And it's not likely to get fixed in our state houses, at least not yet. First, we need to fix this in our counties, in our cities, in our neighborhoods. We need to make sure that there is somebody protecting our rights. And that should start with you, your family, your friends, your neighbors, and your sheriff. And when you can protect your rights right around you, and your friends and neighbors do the same thing, then you've got a sanctuary from which to fight for the soul of your state. Then you can fight in your state house to return liberty and freedom and a dedication to protecting the rights of others in your state laws. And only when we've made enough people in our states that we can change our state houses will there be enough people that can change those in Washington to overthrow those who are perverting the Constitution and to restore the respect of law that was so much part of our history. Now, if you want to learn more, I mean, these videos are great, and I hope you really like them. But I know a lot of people, they want to learn more. How do you learn? Well, there's a couple ways you can go about doing it. First, I'd like to recommend you head to constitutionscholars.com. Now, you can sign up absolutely free, and you can join communities of people that are reading and studying, becoming students. A scholar is a student, becoming a student of the Constitution among themselves. You can bring up questions or ideas, discuss them, debate them, engage with others. Maybe you'll find others in your state or in your city or town, but you can get engaged and participate. There's classrooms there. There's libraries and videos that you can join. Now, the other thing you might try is if you go to the shop, if you go to the store, I really recommend the book, The Constitution Study. Yes, I wrote the book. It is a clause-by-clause study of the Constitution written in everyday common English, in conversational language. As I said, the Constitution was written so an 18th century farmer could understand it. I think a 21st century farmer ought to be able to understand it as well. Take that, read it for yourself, or even better, read it with a group of friends and family. Study it together. Ask yourselves these questions. You may not agree with me on absolutely everything, and I understand we live in a free country. But start thinking along those lines. And if you really want to take it to the next step, well, consider joining one of my mentoring programs. I have 3 of them. When you start out as an apprentice is a learner. And we'll teach you not only how to study the Constitution for yourself, but how you can prepare yourself to teach others so that you can become more independent. Eventually graduate to journeyman, where you're doing more time studying and teaching others than simply learning from your others. Now, there is a chance to become a master. There are going to be very few of those. But this is a place where I'm trying to pair up people who are truly interested in the Constitution with mentors so that you're not studying alone, even if you're not in the same state or even the same side of the country. Have someone so you're not alone as you're growing and being a student of the Constitution. So check all those out. They're there to help you become better educated so you can see the foolishness, the illegality, the unconstitutional, the criminal aspects of what's going on, and then start working to protect our most precious resources, our families, our friends, our neighbors, creating bubbles of liberty and freedom and justice for everyone as close as we have to, then looking to expand them where we can. So I hope you found this useful. I hope you'll check all those out. If you don't want to buy, you don't want to join, that's okay. I still give you plenty of resources to share for free because it's just that important. So please check that all out. If you have any questions, contact me through one of the websites, and hopefully you'll join me here next time for the Constitution Study.
One thing you have to